All right. Hello, everybody. Thank you very much for coming. This is our very first guest speaker series event organized by the International Law and Human Rights Unit. Hopefully, well, not hopefully, we will definitely have more. This semester we changed a little bit the procedure, the process. We will not only have a guest speaker, but we'll have a prominent academic from our law school commenting on that paper. So today we have Alan Greene, and then in a couple of weeks we'll have Conor Gearty from LSE. Then we have Alison Young from Cambridge, and finally Maurizio Arcari, thank you very much, from Milan. Yeah? And everyone obviously is welcome to all of these presentations. Today, Alan, who's a senior lecturer at Birmingham Law School, as the slide says, we'll be talking about parliamentary sovereignty and locus of constitutional power in the UK. So I disappear, and the floor is yours.
Yes, thank you, Constantine. So this paper is coming out soon in the International Journal of Constitutional Law, but there's hopefully the grain of an idea in here for maybe something bigger. So I'm very interested in kind of ideas that you might have, so be as critical as possible is basically what I'm asking you to do. So the kind of topic of this paper is this idea of constituent power in the UK. Where does constituent power in the UK lie, and how does it relate to the concept of parliamentary sovereignty? So the paper itself, it starts off with a critique of the traditional narrative of UK constitutional law and of the UK constitution as being what Dicey referred to as the most flexible polity in existence, as the UK constitution being this kind of dynamic, reactive constitution that's consistently able to evolve over time. And the reason I critique that is because of this idea of parliamentary sovereignty as almost this inviolable constitutional norm in UK constitutional law. And because of its inviolability, it essentially means that all constitutional changes, amendments, forms have to address parliamentary sovereignty or have to accommodate parliamentary sovereignty in such a way. So this idea that the UK constitution is flexible tends to be backed up by some of the suggestions of the big changes that we've seen in recent decades in UK constitutional law. That this has all been possible without actually, needing to write anything down or codify anything in a written document. So examples that are very often given are the ideas of Parliament, of devolution, of the Human Rights Act, of things like that, as examples of big constitutional changes that have been capable of being introduced, but still preserving constitutional law. But devolution, questions of devolution, raise, I suppose, challenges somewhat to the authority of Parliament in such a way. Or at least it demonstrates some fragmentation of authority under British constitutional law. But importantly, devolution, I think, raises, and other kind of recent reforms, such as referendums, raise the question of the relation between Parliament and the people. So between the sovereign Parliament that, under Dicey's orthodox theory, can make or unmake any law it sees fit, raises this connection between the Parliament and between the people. This idea of the people itself is something that's potentially underexplored in UK constitutional law as well, or basically the UK in general. When we talk about the British people, what do we mean by that? Is there a singular British people? Or is the UK, as we talk of it as being this kind of union of nations, is it made up of different people? Is the UK a unitary state, as parliamentary sovereignty essentially requires and as devolution tries to accommodate, or is it more of a plurinational state made up of these different unions? And if so, how does that plurinationalism manifest itself? This idea of the relationship between parliamentary sovereignty and the people or at least this inflexibility of parliamentary sovereignty, is demonstrated as well by the fact that referendums are conceptualized as advisory only. And in the paper, I basically question this idea of whether they are advisory, or at least legally they are advisory, but obviously politically they're very much binding. And I suppose someone could argue that, and people do argue, that that's just an example of how the UK Constitution is capable of accommodating things like referendums. In the paper, I argue actually that this idea of conceptualizing referendums as merely advisory is kind of almost an example of Parliament's hubris, and was one of the reasons why Parliament was so, I suppose, flippant, for want of a better word, in granting a referendum on EU membership in the first instance, because it was only advisory. It doesn't have any legal implications, and Parliament is sovereign, so it will be fine. We can just ignore the result if possible. So this idea of referendums as advisory, I think, is problematic. This idea of the relation between the people and Parliament is something that is very much underexplored, and that the doctrine of parliamentary sovereignty does not necessarily acknowledge. The reason being, parliamentary sovereignty is an institutionally oriented doctrine. It refers to the other constitutional institutions. It doesn't necessarily refer to the relation between Parliament and the people. And even this idea of the people themselves as a concept in British constitutional law and constitutional theory is problematic. Is there even an authority called the people? Arguably there's not. And so, parliamentary sovereignty as well, we can see, generally speaking, it tends to be, as I've said, it's an institutionally oriented doctrine, and it refers primarily, when we're talking about parliamentary sovereignty, its relation to the other branches, and a lot of the research tends to focus on the relation between Parliament and the courts. Okay? And we've seen changes again, devolution, the Human Rights Act, etc., are all about exploring the relationship between Parliament and the courts, but ultimately preserving the ultimate authority of Parliament. So as a result of this, I contend that the UK Constitution, rather than actually being flexible, is potentially in a state of torpor, is potentially unable to deal with these different emerging challenges, not so much from the courts, but from the people, from this conception of one, who are the people, and two, the different conceptions of the people in the United Kingdom, both from referendums and maybe the UK as a plurinational state. So, arguably, these factors are feeding into the UK, into the current, I suppose, constitutional crisis that the UK is facing at the minute, and manifesting itself as a result of Brexit. And in the paper, I argue that essentially the UK it's what Bruce Ackerman would call is facing, I suppose, a constitutional moment, but it's one that the UK actually can't recognise, because it doesn't recognise the people as a constitutional authority, or as an authority. So there's this tension here that legal constitutional theory, or constitutional theory generally, is incapable of recognising. So this raises the question to me of this idea of constituent power, and to try and explore where does constituent power lie in the UK, and how can this doctrine of constituent power potentially be used to reform UK constitutional law, UK constitutional theory, or at least expose some of the assumptions upon which orthodox UK constitutional theory is based upon. So what is constituent power? So constituent power as an idea, it tends to be traced back to Emmanuel Joseph Sieyès from the French Revolution. The Abbé Sieyès, as he was sometimes called, he was a churchman, and he was looking essentially for a justification for the revolution. He was trying to justify the third estate, which was in the general estates. The third estate was essentially the body of the people. The first estate was the clergy, the second estate was the nobility, the third estate was the people. He was trying to justify overturning the ancient regime and instilling a new regime. Ultimately ending up with the execution of Louis XVI and the ushering in of a republic. So he was looking for some kind of legitimating idea to justify destroying the old constitution and creating a new constitution, essentially. And Sieyès describes constituent power as essentially the power of the people to do that. It's about the relation. It's about the relation between the people and the state, and it's the power to create a constitution. Okay, so constituent power, an exercise of constituent power, tends to happen in the aftermath of a revolution, and once constituent power is exercised and the constitution is created, you have what are called then constituted powers. So this separation between constituent power and necessarily requires constituted powers to exist. And constituted powers are those powers which derive their validity from the Constitution. They're essentially are the powers that we consider to be constitutional powers today: legislature, executive, judiciary. So that distinction between constituent power and constituted powers is incredibly important. So constituent power, because it tends to be exercised in the moment of revolution, and because it has this power to both destroy an old constitutional order and create a new constitutional order, it has both kind of constructive and destructive potential. Okay? And there's different models of constituent power, and these models really, I suppose, the key difference between them is whether one considers constituent power to be destructive and maybe a troublesome thing and a scary thing, or whether people consider constituent power to be a good thing, a creative thing, constructive. So, and I suppose this constructive and destructive potential of constituent power is very clear from the fact that the classic example of constituent power being manifested or being exercised is during a revolution, and particularly given that the doctrine has origins in the French Revolution, you can see that. So closed models of constituent power, these are models that basically use constituent power at the start to get the constitution up and running. So it's at that moment of revolution, we'll create maybe a constituent assembly, and we'll establish the constitution. And once those models have got that constitution up and running, there's no need for constituent power anymore. It disappears, it's closed, we don't need it. The machine runs itself from now on. And all state power, as a result of that, is constituted power. The system is closed. The classic, and so as a result of that, the closed models then conceptualize all constitutional powers as limited powers. They're all limited because they've been created by the exercise of constituent power. So theories of unconstitutional constitutional amendments, a lot of them are based upon this idea of a closed model of constituent power. So basically, you cannot even exercise the amendment power to a constitution. That can't amend to constituent power. Okay, that is itself a constituted power. And as a result of that, there are some things that you cannot amend a constitution to do. So the Indian Constitutional Court, for example, has limited the power of the amendment power of its constitution, and it has this doctrine of an unconstitutional constitutional amendment. So closed models, therefore, tend to see constituent power as being quite a destructive thing, quite a worrying thing, and quite a scary thing that we want to banish from the Constitution completely. And even some models of constituent power go so far as to reject the idea completely. So, for example, David Dysenhouse says we should not go near the idea of constituent power, arguably because of its antagonistic relation, or its ambivalent relation between the constitutional order that it has established. So he doesn't like constituent power. Open models of constituent power are a little bit different. So they argue that they don't just use constituent power to get the constitution up and running. They're saying that constituent power can be invoked and used even once the constitution is established as a means of as a catalyst for constitutional reform, as a means of reinvigorating the constitution every now and again. So these models are less concerned about the destructive potential of constituent power. They're more willing to embrace its creative, its generative potential. These models, a lot of them tend to place an emphasis on a link between constituent power and the people. So between constituent power has even been described by Antonio Negri, or Antonini Negri, I think is his name, as essentially being an expression of democracy. It's the essential relation of democracy. So you see this very often in the literature, particularly open models of constituent power, drawing a key link between constituent power and the people, constituent power and democracy. So here's this link that's kind of made very clear in open constituent power. But this idea of constituent power being vested in the people kind of raises a number of paradoxes. So the key paradox is this idea that, okay, the people possess constituent power, but how do we identify who the people are? Okay, well, we can identify that once the Constitution is up and running. Okay, so it tends to be that we can only identify who the people are after constituent power has been exercised and the Constitution is up and running. And so this gives rise to a paradox. How can the people possess constituent power when the idea of the people is itself created by the exercise of constituent power? So you have this paradox here in this theory. And then you have the second power. Well, if the people possess constituent power, do they have the power then to give away that power once they have created? So you might be able to see some of the similarities here between parliamentary sovereignty, some of the paradoxes that swirl around parliamentary sovereignty. So some of the theorists of constituent power, you often see Carl Schmitt being invoked in this regard. And Schmitt essentially conceptualized the state as the political unity of the people. Okay? And he argued that the state was established by this decision to separate friend from enemy by the sovereign. Because once that, basically you can't have stability until that happens. Otherwise, you're just going to have friends and enemies, they're going to be fighting each other. You need to make that distinction, who is friend and who is enemy. And once you've done that, then you have a nice, stable state. And you see this, Schmitt in his early writing, kind of, he talks a lot about, he uses the term sovereignty. But in his later material, he switches from sovereignty to constituent power. But broadly speaking, they're kind of the same thing. And sometimes Schmitt is held up as, I think it's Hans Lindahl who describes him as trying to wrestle democracy free from the rule of law, as a defender of democracy. But Schmitt is definitely not a defender of democracy. Okay, he's a theorist of the Third Reich. So he's not. So I'll talk a little bit more about Schmitt later on, but his idea of the people is very much a homogeneous, ethnically kind of, homogeneous, all speaking the same language conception of the people. So it should, I would hope, well, to me at least, that's quite a normatively problematic conception of what the people are, because of essentially its racist undercurrents or its racist basis. So where does constituent power lie in the UK? Does it have to be possessed by the people? Well, constituent power, there are some commentators on it. So Martin Loughnan, for example, in his earlier work, basically said that we've no need for constituent power in the UK because its function has entirely been absorbed into the doctrine of absolute authority of the Crown and Parliament to speak for the British nation. I think it was around 2007, 2008 he wrote that. De Tocqueville as well talked about Westminster being at once a legislative and a constituent assembly. So essentially Westminster, it can legislate, but it also has constituent power too. And Joël Coulon-Rios talks about constituent power basically not being needed in a constitutional order where Parliament can create any norm it wishes. So UK doesn't really need constituent power. Okay, the system runs, we don't need to worry about it. So there seems to be the central claim that either the UK doesn't need it or that Parliament possesses constituent power. But if Parliament possesses constituent power in the UK, what is the basis of this? Okay, so the conflation of parliamentary sovereignty with the idea of constituent power raises this question of whether constituent power in the UK can be considered to be vested in the people. Essentially, Parliament becomes, I suppose, the locus for constituent power, and its democratic credentials then are kind of used to square the circle between Parliament and the people. Okay, and you see this in some of the more recent theories to grapple with this idea. So Tom Poole, for example, tried to argue that Parliament possesses derived constituent power, and the original constituent power is still vested in the people. So what does he mean by derived constituent power? So he builds upon the idea of Yannick Rosny, who's exploring the concept of unconstitutional amendments and constituent assemblies. And in a constituent assembly, when a country is deciding or a state is deciding to create a new constitution, generally speaking, it's not going to be everybody gets a say in it. There will be some people who are appointed or elected as delegates to the constituent assembly, and the delegates are the ones who will decide what goes into the constitution or not. This idea of Parliament possessing derived constituent power is reliant upon this conception of power being delegated to an individual, and individuals acting as a delegate. Okay? So delegated or derived constituent power then was a very popular explanation for the limited powers of constituent assemblies. The original power vests in the people, but they delegate powers to their delegates, who then are exercising it on their behalf. But because it's delegated to them, it is in a way kind of limited. And this theory arises, particularly this idea of derived constituent power, because people in the US at the time were afraid of what were called runaway assemblies. Okay, they were afraid, well, if we give it to the Constituent Assembly, they're going to do lots of horrible things, like, you know, they're going to take away all the rich people's property or things like that. I'm sure we can't help that. So they limited the power. There's a number of problems with this idea of derived constituent power in the UK, however. And the first one, firstly is this oxymoronic idea, I think, of a limited constituent power. Because arguably constituent power, by definition, isn't limited. So there is some kind of a paradox there. The second problem is this idea that members of Parliament, to whom constituent power is delegated to, this idea that they act as delegates. So this idea of MPs, and arguably of Lords as well, act as delegates of their constituents. Because firstly, the key thing is essentially that Parliament has been sovereign long before it had kind of any meaningful claim to be democratic. So that's kind of the first problem with that distinction. The second problem as well is this idea that parliamentarians act as delegates, when it's quite established that they act as representatives, not as delegates. So delegate very much has to do what their constituents tell them, and are limited by what their constituents tell them. As Edmund Burke has very famously said, representatives don't. Okay, they're representing them, but they are free to exercise their own conscience. Whereas that kind of freedom is lacking for a delegate. The third one is kind of the actual lack of limits on Parliament's lawmaking power. So this is the problem of using a theory of derived constituent power, using Rosny's theory, which is basically designed to explain unconstitutional constitutional amendments, essentially saying there's a limit here to what you can do or not, to try and map it onto parliamentary sovereignty, which is ultimately about Parliament's very unlimited lawmaking power. And then the fourth one is this idea of derived constituent power. Its influence really stems from the United States, as I've mentioned, where there is a very strong fear of a runaway assembly being evident in the United States, afraid of democracy, afraid of assembly. But that fear of a runaway assembly is very much absent from UK constitutional theory, particularly, for example, Dicey's faith in English civilization. The reason why Parliament is sovereign is because we can trust the British people to not, and we can trust the representatives to not, kill all blue-eyed babies. At least that's the orthodox theory anyway in that regard. So other theories then of constituent power. Hannah Arendt then, she comes along and she says that in her description of kind of the English Civil War and ultimately the Glorious Revolution, is that what you had was basically the sovereign of the nation was replaced by the monarch, with the sovereignty of the nation replaced the position of the sovereign monarch. So get rid of the monarch and replace it with the sovereign of the nation. And as a result of that then, Parliament stepped in and basically took the place of Charles I, and then subsequently the Glorious Revolution, William. But William had limited powers. But whether the sovereignty of the nation can be equated to the sovereignty of the people, Parliament's possession of constituent power can be equal to the possession of the people is a different question. So I would question very much whether we can simply square the circle between Parliament possessing constituent power and it saying it's possessed in the people. So what are the other bases for the claims to constituent power? Well, if you read Schmitt, although Schmitt's kind of mentioning an acknowledgement that constituent power can be vested in the people seems to be what's taken over the literature today, and people seem to focus upon that. What people tend to forget is Schmitt also identified two other sources in which constituent power can lie. It can lie in there can be a monarchical basis of constituent power, and there can be an aristocratic basis of constituent power. So aristocracies, for example, that would have possessed constituent power, or sometimes oligopolies would be, for example, the Venetian states, in Florence as well. So Florence, when you had the very strong families that ruled it, that constituent power was possessed on an aristocratic basis. The monarchical basis, hopefully, is self-explanatory. The constituent power is vested in a monarch. And the paper argues as a result that these anti-democratic bases are potentially evident in the UK too. The UK was a monarchy, but then when you had the eventual revolution, at the time I would contend that Parliament wasn't democratic, and it was essentially rested from an aristocratic basis. So you had a movement to an aristocratic basis. And although the UK has become more and more democratic, these anti-democratic bases are still manifest in Parliament's claim to constituent power today. So the paper is trying to expose if Parliament does possess constituent power, it's arguably there are still anti-democratic elements there, and we should acknowledge them and be aware of them. Probably the best attempt at explaining the locus of constituent power in the UK today is the work of Martin Lachlan and his theory of relational constituent power. So this is essentially, it's an open theory of constituent power. And he views constitutional ordering as being dynamic and never static. It's never changing. The Constitution is constantly evolving. It never stops changing. But he's also very much aware of the absolutist claims of Schmitt, or that's what his paper condemns anyway. So, for example, he is aware of the destructive potential and particularly destructive potential of Schmitt's conception of constituent power as a sovereign being able to break in and make this distinction between friend and enemy and create the necessary stability. So how does he do that? Well, he tries to make a distinction. He tries to contend that constituent power is vested in the people, but that doesn't mean that political authority is exercised by the people. So he tries and makes this distinction between constituent power and political authority. So he's making an emphasis, he's making a claim and an emphasis on representative democracy rather than on popular democracy. Okay? And he's saying what constituent power tries to do, and what relational constituent power tries to do, is establish a dialectic of right, what he says, between the rulers and ruled. So constituent power is essentially, it's this idea that's constantly seeking to irritate the institutional lines of constitutional authority. So it's like the people and the rulers versus the rule, and they're in this dialectical relation between each other, and in that tension from the people holding the rulers to account, the ruled holding the rulers to account, that's where the constituent power of the people manifests itself. However, he also cautions against consuming constituent power into the constituted powers, because if we do that, we lose constituent power's creative potential. If we say all state power is constituted power, then constituent power can't have that irritative function to kind of, reinvigorate the constitutional order and make it more dynamic. So Lachlan, as a result of that, he insists on the people being able to challenge those who claim to speak on their behalf. And it's in that challenge, then that's where we get constituent power. So, what are the problems with this? Well, I think my main contention with it is essentially all appeals to constituent power tend to involve some sort of challenge to the constitutional status quo. If you're invoking constituent power, you're trying to say there's something wrong with the existing constitutional order. And we need to change that. We need to do something radical to change it. Lachlan's, however, I feel, and I'm not sure whether he admits it, but I think he's trying to actually legitimate rather than challenge the existing status quo. So he supports dynamic, albeit slow, incremental constitutional change. So I don't think it's trying to challenge the status quo, it's trying to legitimate it. And as a result of that, I find it very difficult to see how constituent power is actually not collapsed into the constituted powers. And as a result of that, how his theory, when applied to the UK, doesn't end up losing the creative or iterative potential of constituent power. And this is arguably, and ultimately what you end up with is this idea of an enfeeblement of the people, okay, and the enfeeblement of constituent power. And this is arguably, I think, inherent to his theory of a relational constituent power. And it can be traced back to Locke's theory, where he puts a lot of emphasis on Schmitt, and he says he is influenced by Schmitt. And Schmitt himself only embraced the people as a possessor of constituent power because he'd found a way to tame them. Basically, he said, he doesn't like the people. Schmitt does not trust the people. He's an authoritarian. But he said they could possess constituent power because he'd found a way to tame them through the rule of law, through democracy. So by basing his theory on Schmitt, he arguably, and then applying it to the UK, he's searching for a theory to legitimate the status quo. You end up losing this creative potential of constituent power. You end up legitimating the status quo. So that's my main critiques with this idea of relational constituent power. As a result of this, you could potentially see referendums in the UK maybe as being a point of irritation. But again, because it's only advisory, it becomes difficult to do so. So what are kind of my main conclusions as to where constituent power might lie, given my, lengthy critique of the existing explanations? So my claim is that, okay, essentially it's this idea that Parliament's sovereignty is stopping kind of more dynamic constitutional reform. But Parliament's possession of constituent power is weak. Its democratic basis is weak. Okay, there's only one branch of Parliament, the House of Commons, that has any meaningful claim to be democratic. And then you can critique a lot of methods in which it isn't democratic. You can critique the first past the post, etc., etc. As a result of that, then, you still have very strong aristocratic and arguably monarchical elements of constituent power still element. So Parliament possesses constituent power, but these anti-democratic bases are still very clear. My argument is that this should be acknowledged. Okay, and this inherent illegitimacy of the possession of constituent power should be acknowledged. And if it's acknowledged and it's revealed, then I think this idea of approaching parliamentary sovereignty for more true and meaningful reform could be broached. So, for example, through a more, firmer devolution settlement that isn't reliant upon conventions to implement it and to keep it safe, because there have been examples in which convention has broken down recently over Brexit and claims that Parliament has breached the Sewell Convention. So by recognising and acknowledging this and acknowledging the arguably anti-democratic basis of constituent power, even if it isn't used as a catalyst for radical constitutional reform, it might act as a brake on certain proposed reforms. So, for example, the proposal to put something to a referendum. If this potential tension that exists between Parliament and the people is better understood, then maybe Parliament will be more reluctant or will question whether to put a question to the people or not. But this idea of thinking of constituent power and thinking of the people should make us think a bit more about what do we mean by that. What does the UK mean by the people? Who are they? Is the UK a unified state, or is it more of a plurinational state? So in my theory, ultimately my claim, so this is kind of what I've been working on recently beyond the paper, is to, again, as I've said, to recognise and acknowledge illegitimacy, then constructing theories of legitimation. So my current work is what I'm trying to do is construct a descriptive account of constituent power, rather than an account that axiomatically assumes constituent power has to be vested in the people. And through using this descriptive account of constituent power, identifying where the locus of constituent power lies in different states. The people then use the people, or the people as possessing constituent power, as an ideal type. So it's different to Lauchlin's position, where Lauchlin, there is an assumption that the people possess it, and there's this dialectic between rulers and ruled. I don't start with that assumption. I start with this descriptive account, and I use the people possessing it as an ideal type, and it's about examining different constitutional orders with a view to seeing, where we can take that, where we can assess where that locus of constituent power actually lies. So for basically, I think, Lauchlin's theory, ultimately, it is quite strong, I think, but I think he must insist on questioning how the people can challenge those who claim to speak on their behalf. And it's arguably that, when applied to the UK, that it becomes slightly weaker, I think, particularly with this idea of referendums being merely dismissed as advisory. So ultimately, that's kind of where I am at the minute. So I'm hoping to, in future work, to kind of apply this idea of a descriptive account of constituent power to other models that are other constitutional systems that maybe have a similar kind of origin or genesis from the UK, from the empire. So looking at Canada, Australia, New Zealand, and looking at where the locus of constituent power lies in those states. So can we say constituent power is vested in these states, is vested in the people, when a lot of their constitutions were given to them by the imperial parliament, or at a time where a lot of people were disenfranchised in those states. So particularly in Australia, for example, and the kind of disenfranchisement of Aboriginal peoples. Can we say that constituent power is vested in the people? If it wasn't at the time, but have different constitutional processes and reform to rectify that. So that's kind of my future work, and that's the paper for the moment. Thank you.
Thank you very much, Alan. Now I give the floor to, if you can, to Professor Mike Gordon, who will give some comments and ideas about the paper.
Thanks a lot. Thanks, Alan, for a very interesting paper. I've been fortunate enough to have a copy of the written paper in advance, so perhaps some of my comments will add into some of the things you discussed there that you haven't maybe talked about today as well. But I fully recommend it. It's a very good paper, well worth reading when it comes out. So yeah, thanks. I've long been saying we should have more parliamentary sovereignty seminars in the International Law and Human Rights Unit. So this is a very welcome opportunity to have a discussion on that topic. So I've sort of got three sets of comments or questions, some of which have got questions in there, maybe challenging aspects of what Alan says. But the sort of starting point would be that I agree with quite a lot of what you're doing, and I think a lot of it is very interesting as well. I certainly agree with the unpacking of the democratic character of Parliament's authority. I think that's fascinating and very important. It needs to be done more in the literature. I think the other thing that I agree with you particularly about is, and this is sort of my first comment, is the idea that there is a flawed conflation of constituent power and parliamentary sovereignty in the UK Constitution. That, I think you're right, that has to be wrong. But I guess I'm a bit sceptical that it is a conflation which has been hugely influential. And you've got your quote from Lauchlin, sort of early on in his work, kind of assuming it, but I wonder whether that's a bit of an offhand remark from him. And I don't know how far in the broader parliamentary sovereignty literature people actually do think that parliamentary sovereignty is conflated with constituent power. I mean, you can understand why people see a similarity between the two of them, because they are both ultimately about unconstrained power. So the line between constituent power and parliamentary sovereignty is very thin, bearing in mind they are both about the basically unconstrained power. But I think there's an important difference between the two of them, which is one is an intra-constitutional principle and one is an extra-constitutional principle. Parliamentary sovereignty is very clearly part of a constitutional order. It is an institutional arrangement within the UK Constitution, and I'm not sure how constituent power can be viewed as a sort of intra-constitutional principle, almost by definition, because as you so very clearly explained, constituent power kind of stands in some important way outside the Constitution, whether it does so momentarily at the start and the formation, or whether it does so in an ongoing way in the kind of more relational accounts, which I tend to think, like you, are better ways of characterising the relationship. I think there are just some fundamental categorical differences between these ideas. And yes, I think one of the consequences of that might be that if we're saying constituent power is an extra-constitutional principle that sits outside the Constitution, and that's where popular sovereignty or the people have their power, which I think is the best way of characterising that in a democratic system, well, that might eliminate the people, which I think is something that you're concerned about and something that I might be concerned about. But that strikes me as just a perennial problem for any constitutional system you could ever design anywhere. At some point, once you take constituent power and put it into institutional arrangements, the whole point is to, well, your language is enfeeble the people, but the alternative way of looking at it is to create institutions through which decisions can be made and action can be taken. So I would say I agree with you that those things are wrongly conflated, but I'm not necessarily sure that the right, and this is probably predictable bearing in mind the work I've done on parliamentary sovereignty, but I'm not necessarily sure that takes us to the line that we have to abandon parliamentary sovereignty to correct the conflation, as opposed to just be clearer that these two are very different things and assess them fairly as being different principles operating in different contexts. So that would sort of be my first comment/question. The second one, which is maybe something that you didn't focus on as much in the paper today, but you do in the written paper, which I think is very interesting, is this idea that then parliamentary sovereignty becomes a barrier to sort of constitutional reform. And you kind of gestured a little bit in what you were talking about today when you're saying Martin Lachlan is his account legitimising the current status quo because it's sort of embedding this kind of slow incrementalism in terms of political change. And you know, I can certainly see the argument there, but I guess again, I wonder if we just need to think about parliamentary sovereignty slightly differently and not just think about it as a kind of. You seem to think about it in symbolic terms almost in your paper. I don't know if that's a fair characterisation, but that struck me very clearly. Whereas I think it is a symbol, definitely. It stands for something. It represents values in the constitutional system. It is like a kind of symbolic focal point that we look at to understand the UK Constitution. But it's also an instrument as well. And I think the instrumental facet of parliamentary sovereignty maybe is sort of missing here. And I think when you look at this sort of the instrumental approach, then actually many people who defend parliamentary sovereignty take it as a very significant fact about that doctrine, that it is an instrument that allows radical change to be implemented in a very short space of time. So Keith Ewing, for example, has long defended parliamentary sovereignty on the basis of kind of its ability to be used for transformative political change. So there's a whole wing of people basically who defend this doctrine, largely because it does allow for radical change in a short space of time. So again, I'm sure you're right. I'm sure Lachlan wouldn't say he's legitimating it at all in that account. But even if incrementalism is built into his account, that seems to me to be just one way of approaching parliamentary sovereignty rather than the only one. And I suppose on that kind of front, as thinking about that would be the conceptual side of thinking about parliamentary sovereignty as a barrier to reform. Maybe the empirical side of it is, as you gesture at, if we think about it empirically in the last 20 years or so, well, actually we've seen parliamentary sovereignty used for vast swathes of constitutional reform in the UK system, much of it constraining Parliament's power in informal terms. But we've seen devolution, we've seen human rights, we've seen referendums, we've seen huge amounts of change delivered through the doctrine, which again suggests to me maybe it's overstating it to see it as a barrier for reform. But I appreciate that that's kind of that judgment is a mixture of the way I would understand it as a concept, and as well as a kind of, I'm not claiming to be, this is an empirical objective assessment or anything. But it just strikes me that might be a tension in what you're arguing as well. And I guess the final point is when you talk about the need for a sort of a paradigmatic revolution, we need to move away from parliamentary sovereignty as a paradigm concept, and that is sort of the crucial step that we need to sort of redevelop the UK's constitutional system, which I think is an argument you make very, very powerfully and in interesting ways. But I guess my question or my reaction to that is, well, but where does that actually take us? Because you kind of identify in the paper, and the written paper, a little bit some of the kinds of things you're thinking about. You're thinking about, so Alan talks about how we should move to the idea that referendums are seen as binding rather than advisory, as being one of these kinds of things that this paradigmatic revolution would allow us to do. You talk about an interesting critique of constitutional conventions, and talk about the idea that we need entrenched constitutional norms, not conventions, in many of these areas, particularly around the monarch's powers, which I think is very interesting. And then as you talked about just at the end here as well, the kind of idea that you could have a more federal system recognising different peoples throughout the UK as well. But I guess kind of what I come back to on that, and this is probably a predictable comment, is well who's going to enforce and police those norms? And it's going to be, realistically, it's going to be the courts, I think, rather than the people engaging on a regular basis to kind of enforce the parameters. So it all starts to sound to me like almost a traditional codified constitutional system that you're pushing towards there. And maybe that's a little bit unfair, but then the argument about parliamentary sovereignty has always been one about a relative legitimacy assessment of courts and legislatures. So that takes me back into the same territory as, well, which of these has accepting the major imperfections with the UK Parliament, which you rightly point out, the qualified and limited nature of its democratic claims, those are still, in my view, relatively better legitimacy claims than the courts. And the whole idea of parliamentary sovereignty is that then we leave the authority to police the system with the institution that has the greater democratic claim. And yes, that's not Parliament as an agent of the people directly, but it is a more democratic system in itself. So I agree with you. I would love to see radical reform of the UK's constitution in 1,000 different ways, and I think that's important. And I think the call to push towards that is a very welcome and important one. But for me, the focus would be on it, thinking about innovative, especially if we want to bring the people back into it, is thinking about innovative substantive reform, through institutions and procedures, rather than kind of falling back on more well-established ideas about, an entrenched constitution, capturing the current status quo, which might, to me, it looks like it's novel, but in many ways it's novel to the UK, but maybe the novelty of that is a bit deceptive as well. So those are my comments, but I really enjoyed the paper. I think it's really, really interesting.
Thank you, Mike. I think we'll have to give an opportunity to reply to Alan for a couple of minutes. I really like your comments, especially the last one, and I have my own view on that.
I'm sure you'll abuse the chair's privilege. So.
No, I won't. So we'll give Alan a chance to respond, and then we'll open the floor for questions and comments.
Yeah, thanks. So they're really helpful comments, and I think a lot of them link up to this one point. So this idea of interconstitutional and extraconstitutional, I sort of touch upon that, I think, in the paper, and I think that is itself a potential problem with the UK constitutional order. It is, if parliamentary sovereignty is, if we, as you said, we can't necessarily marry it up with constituent power, but it is the kind of ultimate, I suppose, apex norm of the UK constitutional order, then it's the epitome, arguably, of a collapsing of the constituent power into constituted power. So that would kind of be my response to that, and I think and that in and of itself is leading to an enfeeblement of the people. And I think in the paper I touch upon briefly the idea of parliamentary sovereignty itself evolving from the orthodox theory to a self-embracing theory of parliamentary sovereignty. But arguably that change is itself being done by the institutions that you're critiquing. It's been done by the courts. So you have this radical, I would contend, the most radical changes in UK constitutional theory, changing the doctrine of parliamentary sovereignty. But are the people involved in that change? So if the alignment of constituent power with parliamentary sovereignty is not perfect, and I agree with you, it's not, the ramifications of that are maybe not necessarily, negative impact for Parliament, but potentially negative impact for the people. And just I think that kind of leads to the second point that you were making about parliamentary sovereignty as a barrier to constitutional reform. And yes, we had all these big changes, but if you think about the largest changes in the UK have arguably not even been recognised by parliamentary sovereignty, and basically it's like we don't talk about it, and that is kind of the ending of empire, and it's the independence of Ireland. So those kind of things cannot be, I would contend, explained by the theory of parliamentary sovereignty, that if past parliament can't limit a future parliament, well, they very clearly have. Okay, the UK cannot legislate for Ireland anymore. And I know some people would argue, well, theoretically they can. I think Denning makes this point. Well, theoretically we can. It's just, we can legislate, but it doesn't have any factual impact. And I think there is a very big problem when you have this very clear distinction between fact and theory. So that explanation might work, but I find that, if you have such a clear dichotomy between the two, then your theory is wrong. Okay. So, Parliament has limited itself. It has limited itself, but we don't talk about it. So leading then, and so in terms of the kind of the radical reform and where does that take? I probably am in favour of a codified constitution, but I don't necessarily mean that means you have to, actually, but it doesn't necessarily mean that you actually have to give the courts the final say. And I think we tend to obsess quite a lot on the courts having the final say. And you can have a democratic override mechanism, in that event. And I think, even if that isn't the ultimate goal, let's have a radical reform of codified constitution. I think the important thing is actually just to be aware of this. Be aware of this tension between Parliament and the people. Be aware of these different conceptions of the people. And I think parliamentary sovereignty as a doctrine potentially does instill a degree of hubris in parliamentarians. So Parliament might be sovereign, but it's been quite flippant in how it has exercised that sovereignty. It's good, it has a very strong democratic mandate, as we've mentioned, against courts, but does it have as strong a democratic mandate as against, for example, the devolved institutions, who are also democratically elected? And the doctrine of parliamentary sovereignty, can you legitimize it on a democratic basis versus the devolved institutions? I'm not sure you can. Versus referendums, I'm not sure you can. But even if you want to keep the status quo, I think being aware of this tension is at least going to be important in terms of if you are embarking on constitutional reform on something like putting a question, a referendum to people, you actually think very, very, very carefully before doing it. So I'm not sure if I've wholly answered your question, because they were really interesting and lots to think for, especially for hopefully what will be the next project. So,
Thank you very much. Shall we collect a couple of questions and comments for Alan? And can I ask you to introduce yourself before you start your question, because we don't know all of you, unfortunately. Please. No questions. Vasilis, you saved the day.
Well, actually, two points. The first one echoes to a certain extent the first set of comments by Mike, but again, they're both coming from the perspective of someone who is not a constitutional law lawyer, so from the perspective of the public international law. But literally, I mean, the translation of the term constituent power coming from pouvoir constituant means the power to constitute. And then once something has been constituted and you have this system running up, as you said, then the rest are institutions within that system. So unless there is a particular reason, because again, from my perspective, yes, we have that kind of, concept of parliamentary sovereignty, which is exceptional in a sense comparing to other systems. But leaving this aside, especially the dimension concerning judicial review and the limits of judicial review, the rest of it, from the perspective of someone who is outside from this constitutional bubble, this is a typical parliamentary model. Okay, so you have had in the past a constituent, pouvoir constituant. It somehow established an order, a system. This is running, and then you have a parliament which is running like all other parliaments, with the sole difference that you have this sovereignty, okay, next to the parliament, whatever this may mean from the perspective of domestic law. So this is the first point. And the second point with regard to this tension between referenda and people versus the parliament. Again, this is something that you can find in all other legal systems, okay, where you do not have that kind of existential anxieties about, where the constituent power lies, etc., because these are, in a sense, solved because, A, you have a written constitution, and second, because historically speaking, you can, clearly say that there was a people that declared its independence. that state has been recognized by other states, and therefore you have an entity, you have a new legal order which is functioning, is operating. So this tension is inherent in the way polities function. It is the distinction between representative democracy and direct democracy, and it is a characteristic that it is not exclusive to the UK.
Thank you. Any other comments, questions? Yes, please.
Thank you. I'm Daniel Hill from the Department of Philosophy. Thank you very much for your talk. My question concerns your statement when discussing the closed model, quote, all subsequent state power is constituted and therefore limited power, unquote. And my question is, why? Why does it follow from the fact that it's constituted that it's limited?
Thank you. And maybe one more.
You can abuse your position.
I will. But Michelle, is it a reluctant?
Slightly reluctant question. I really enjoyed the paper. I enjoyed the conclusions in particular because I like the idea of of them admitting to their illegitimacy. In a sense, we're stripping back the kind of the core of the political state. But I guess once more, why would they do it? Why would they censor this? What was being said?
Okay. All right. So let's give Alan a chance to respond, and then maybe we'll go for another round.
Okay, I think, that idea kind of demonstrates the problem of closed models of constituent power. So closed models, and ultimately constituent power is about legitimacy. It's about the legitimacy of the constitutional order, the legitimacy of destroying the old and then creating a new. Closed models, however, face the problem of why is the existing constitutional order still legitimate? Why do we give preference to some lucky generation who just so happen to be around? Why is what they've set down in the Constitution still valid? So closed models, in a way, there is this legitimacy problem, I think, there, and that's kind of why I favour and prefer this more open model of constituent power. This idea that the people can still come in, so that if the Constitution is still in existence, that its claim to legitimacy can still be attributed to the people who are still alive rather than people who existed 200 years ago. So, I think that is potentially why I favour the open constituent model, and might answer, what I mean by when departing from this idea is just it being the power to constitute. Although linguistically and originally that's where it came from. Sayers wasn't himself worried about the future generations. He was worried about what was going on, I suppose, at that very moment in time. He didn't need to worry about the future generations. It's kind of us now trying to think about why is it still legitimate when the constitutions have lasted so long. So I think that's why I prefer those kind of open models. In terms of whether it's only exclusive and an issue that only affects the UK, I agree 100%. It doesn't just affect the UK potentially. It affects I think it affects every constitution, and every constitutional order needs to be thinking about where this locus lies. I think I've homed in particularly on the UK as one. I'm living here now, and two, because I think that the idea of parliamentary sovereignty, and particularly recent theories like the Republican theories by Bellamy, for example, laud the democratic credentials of the UK. So I wanted to kind of interrogate that a little bit more. But my critiques definitely wouldn't just pertain to the UK. In terms of why are all constituted powers limited, I suppose this is just from a kind of classic legal theory that if you delegate power or give power to someone, they cannot stray outside the bounds of the power that they have been given. So any power that has been conferred or created should by definition be limited. If it's not, I suppose the claim would be, if it's not limited, then it's still constituent power. So the problem with that, or at least some theorists would argue, the problem with constituted powers not being limited is that you arguably don't get the stability necessary to found the state in the first instance, because the exercise of constituent power has not managed to create that requisite stability. So the constituted powers that tend to be created by the exercise of constituent power are things like, legislative, executive, judicial, and those powers tend to have bounds within a constitutional order. I suppose in theory then you could say, well, constituent power could create an individual or body that doesn't have unlimited power. And that would arguably, I would contend, align with Schmitt's conception of the sovereign. And he sees, but under Schmitt's theory, the sovereign breaks into the constitutional order, and then he creates the stability, and then he backs away again. So in that instance, the sovereign power, its unlimited aspect is designed to be exercised in such a way to create the limited powers. If that makes sense?
Am I allowed to come back on that?
Yeah.
Okay. Yes, so it was what I had in mind was the second thing that you said there. So why couldn't it be that the sovereign or the people, whatever, constitutes a body with unlimited power?
So Schmitt would contend that it wouldn't be law that does that. That's just force that does that.
But sorry, the statement was all subsequent state powers constituted and therefore limited power.
Yeah.
You didn't mention law. I took it that your point was it was inherent in the idea of constitution that it was limited. But now you're saying that force can constitute something unlimited. Is that what you're saying now?
I don't think so. So, in terms of that quote, I might just pull it up if it's actually about closed models. Or
It was about closed models, yeah.
Yeah. So closed models would contend that all state power is limited. If you essentially a closed model would say if you have created a body that still has that unlimited power, then that's still constituent power. So you've not actually gone about and founded a constitutional order. You're still in that constituent assembly state potentially.
Well, what's the argument for that? I mean, what I'm asking is why, really? I mean, so it says therefore limited power, but why isn't it possible on this theory to have an unlimited constituted power with unlimited, a constituted power with unlimited, constituted body with unlimited power, let's say?
Under closed models, it's because, well, the entire purpose of exercising constituent power in the first place is to constitute a constitutional order. If you have unlimited power, then arguably not constituted anything. That's potentially, that could be one claim. The other claim is then you have this unfettered constitutional authority, and again it's something that Schmitt has contended that you can have. But he would see that as an open model, he wouldn't see that as a closed model, because it's the power coming in. Closed models are about banishing that absolute power completely. It's the entire purpose of it. If you don't banish that absolute power, your model is not closed. It can still come in, it can still break through. And Schmitt was trying to preserve that idea of a powerful sovereign to be able to break through. And basically he says you need, without the exercise of constituent power, you don't have that stability necessary in the first instance to create the state, and to have those different organs then come along and operate effectively. But even when you do have that, you're still going to need that powerful body to come in and break through the norms in a state of exception to basically re-establish the stability. And particularly he was trying to critique liberal democracies, saying they're never going to be able to create that kind of necessary stability because they're too polite to each other, and they ignore the friends, or they ignore the enemy distinction, and they end up basically they'll descend in, and you need that sovereign to come in. So I think that would be my answer.
Thank you very much. Thank you. It's very helpful. Thank you.
There was a question from Michelle.
Which was, why would they?
Oh yeah.
Well, I would hope the current things that are going on in Parliament is a good idea to think that maybe we should think a little bit more about this before we go on and embark upon constitutional reforms in future. That would be my suggestion. You know, why would they demand? They probably won't. I'm not sure if that's a help at all.
No, it is. I guess maybe it wasn't a fair question in a way, because you're saying that we should expose it as opposed to they should expose it. But
Yeah. I sometimes feel a lot of my work's kind of like it's like Captain Hindsight. It's like, you know, maybe you should have thought about this first before doing this. But you know, there'll always be a future time, and maybe, you know, if they learn from what's happening now, it might be a good advice for what might happen in the future. Sorry.
Thank you, Thomas, and then Rob.
Hi, Thomas Horsley, University of Liverpool. Thank you very much. Really fascinating paper. It got me thinking about a number of things. But I think I'll maybe stick to my kind of overriding reaction is I mean, a lot of what seems to be bothering you are perhaps weaknesses in the current constitutional system from sort of like a liberal perspective. You've mentioned the fact that Parliament isn't entirely democratic, particularly around the Lords. You've got the issue of perhaps the devolution settlement isn't quite as you like it to be or as it could be, and you've got other issues around the kind of responsiveness of Parliament to referendum and various other things we could go on. And I guess you're discussing a lot of what you're interested in, of course, is the kind of classic public law stuff. It's about legitimating public power, legitimating constitutions and things. And you're obviously looking at this through the lens of constituent power. But I'm sort of playing devil's advocate here a little bit, but is there perhaps a little danger that using those concepts, and I would include Locus and other people in that, you're kind of trying to retrofit the UK experience, the constitutional experience of the UK, to a sort of theoretical set of developments which, let's face it, were developed mainly around the kind of European constitutional tradition and maybe also, of course, in the US and stuff, but were developed outside of our constitutional experience. And I guess there's been an attempt by some to kind of try and reconcile the two. So I'm just kind of wondering if the main thing that's bothering you is actually kind of constitutional legitimacy or just legitimacy generally, and then also issues of constitutional functioning, kind of liberal democratic values and the kind of weaknesses in our system. I mean, that seems to be the kind of drive, and I'm just wondering the extent to which the discussion of constituent power actually just kind of maybe perhaps muddies the water a little bit. Because I happen to believe, and Mike mentioned this earlier, that actually Parliament and the doctrine of sovereignty can function in ways which both give rise to these legitimacy tensions. For example, by creating the devolution settlement, it has, of course, in one sense, legitimated sort of embryonic constituent claims, which could potentially be slightly problematic in that sense. But in the other sense, it's a very powerful tool. Parliament can use its legislative supremacy to fix a lot of the things that bother you in that sense. And there certainly isn't sort of a constitutional obstacle to its doing so. And maybe it's just the case that what is needed here is more responsiveness from Parliament, a more democratic settlement, a more democratic exercise of its legislative power in that sense. So I know there were kind of 2 points there, but I did find it very interesting, but it did make me question the importation, if you like, or the retrofitting of these perhaps, as I say, concepts, ideas and theories that developed ostensibly outside the UK constitutional experience.
Rob?
So actually, in a way, I think I might be slightly reformulating Thomas's question, but I'll do it anyway. I wonder if there isn't a problem about the kind of the abstract conceptualization of constituent power in this sense, because it seems to me that constituent power, as it is articulated in this classical sense, is very much tied to like the idea of essentially a bourgeois revolution, and that's a moment at which you can have the legal and the political fusing to do a thing later. And so in that sense, it's not just that it's alien to the UK's constitutional tradition, I think it is, whatever that means, but it's like it's almost in the sense that because something like that did not ever happen in the context of the United Kingdom, I'm not sure that it's convertible into a concept in the same kind of way. And part of the reason why I maybe have then my doubts about this idea of descriptive, like the idea of constituent power descriptive, in the context of somewhere like the UK and other places, outside of that particular revolutionary moment, how is that not just a kind of constitutional descriptivism? I don't know what the stakes are of calling it constituent power at that moment, because you can't pinpoint this kind of historical, theoretical, legal moment in the same way, so I don't know what the stakes of it are. And then I think linked to that, I do wonder on that basis, because of that, how separable the notion of constituent power is from the notion of the people, as it were. I can kind of see where you would get at and why you would be doing that, but in lots of these accounts, because of that moment, the people does seem to me to be central in that kind of thing, and I wonder if there isn't a very distinct and specific thing that, actually, as far as I can see in the context of the UK, because of the kind of the nature of the way in which the democratic settlement was developed, which you alluded to. And this is kind of like, Perry Anderson and Tom Nairn's thesis about the kind of incapable revolution. There was never really any political tradition in Britain that invoked the people as a political subject. That never really happened in that sense. Because of that piecemeal thing, because of that compromise, because of the lack of the bigger revolution, you kind of skipped from this kind of the feudal thing to the labour movement. And so all of this just makes me wonder if, and this is this is my problem with constitutional theory, some of this is about taking a particular thing, abstracting it into a concept, and trying to project it in a way that doesn't make sense in a particular set of socio-historical circumstances. And I just wonder, when you do it, when you think about it like that, what are the stakes of calling something in the UK constituent power, given that kind of mismatch?
Thank you, Ben.
Happy to wait, they've been quite long, or not long, but I mean there's a lot there, isn't it? I'm happy to go as well.
Do you want to answer, or?
Yeah, I can try and answer. I think both of these points potentially questions raise this idea of British exceptionalism, and why there's something exceptional about the UK that kind of makes it impervious or immune to analysis from other constitutional theoretical perspectives, and I don't think the UK is. I don't think I know we like to talk, I know UK orthodox constitutional theory loves to laud this exceptionalism of the UK, but I think it's very much possible to apply this idea of where asking the question of where this constitution came from. Why is the constitution the way it is, and why is it legitimate in the way that it is? And constituent power is ultimately about asking that question and interrogating that idea. And I suppose that's what I'm trying to do with this paper. Where does this constitution come from? Why is the constitution the way it is? Does it need to stay the way it is? Can it be challenged? Can it be reformed? So, and I think you can. I think you can use the tools of constitutional power to do that in the UK. And I think the fact that it hasn't been done, that's kind of what I'm trying to look at in the paper. The fact that this idea of a tension between the people and Parliament has not been explored is deeply problematic, deeply questionable. I think it's also some of the literature on Scotland and the distinction between Scottish conceptions of Parliament, of popular sovereignty, particularly around the Acts of Union, versus English conceptions of parliamentary sovereignty, I think is quite interesting there, and whether we need to think a little bit more about those relations between the two. So that's what I mean, like kind of the literature on Scotland, and the UK talks about the UK as a family of nations, but is there any legal consequence of this idea that the UK is made up of 4 different nations? I don't think there is. I don't think that conception of separate nations actually makes any kind of a difference, at least from the parliamentary sovereignty perspective, because legally the UK is a unitary state. So I think I'm not sure if I've answered your question there, but I think I would claim that constituent power is this capacity to interrogate where a constitution came from and why the constitution is the way it is and why that is legitimate. And I don't think the UK is potentially immune to that. In terms of Rob, your question about this idea of trying, arguably it is looking at the myth of the people, and I agree absolutely that every constitutional order seems to have this narrative of the myth of the people, and if you look at considering the constitution to be created and bested by the people to be problematic, absolutely yes. And I think that's sort of what I mean by a descriptive account of constituent power, and using this idea of the people possessing constituent power as an ideal type, rather than, and in that way trying to acknowledge that illegitimacy and trying to use that as a means of stress testing and interrogating not just the UK constitution but potentially every constitution in that way. So I am like yourself deeply aware of this myth in every constitution that the people possess the power, and that's why I try and avoid this axiomatic assumption that the people do possess. So I'm not sure if I've answered your questions very well there, but this has been it's been really good, and it's really helped me to think about it.
Thank you. We'll take two more questions from Ben and from the gentleman over there. Oh, Rob, you wanted to say something?
So I'm not going to be a dickhead,
Ben Murphy, also from here. Thanks, Alan. I really enjoyed your paper. There's so much to get into. If we're framing the question of constituent power in the way that you described it then, so the question of where does the power come from and why is it the way that it is, I think more than some other people I do see something complementary about the idea of constituent power and parliamentary sovereignty, if only in this symbolic sort of legitimising the exercise of power sense, so something in the democratic credentials of parliamentary sovereignty, or something in the broader conditions of the political constitution that limits what would otherwise be an unlimited legislative power. But what we see here then is the people acting in this sort of mythical, symbolic way as being that we justify the way that we exercise power in an active sense because we have to legitimise it in the name of the people. And all actual active, the exercise of active power is always in Parliament. Even in the examples that we use where we think about referendums, this is Parliament gesturing to the people to say, in this instance, we'd like to see what the people think. And this is where I think we've heard a few times this afternoon when constituent power folds into constituted power. And I was just wondering, it is an equally important question not at one point does constituted power flip back to constituent power. And so I'm wondering whether there's room in your ideal type or in your group of examples for when the people exercise power in a more active sense, so like ground-up movements. So I suppose my question is there room in the ideal type to make constituent power less of a myth? So is there room for mass protest movements, extension rebellion, change.org, these type of things?
Thank you, Ben.
I'm Adam Water. I'm a teaching assistant here. My question was just on, I think in the presentation you kind of set out two ways that constituent power can function. So one was as a point of irritation, and the other was kind of legitimising. And you saw that Martin Laughlin's model is more legitimising, and what I think you're defending here is constituent power as a point of irritation. I'm just wondering how this might kind of the consequences that this has for how we use referendums. So I would kind of think that at the moment referendums, especially the EU referendum, was used as a point of irritation in the sense that the people were given the opportunity to require Parliament to follow a course of action that the majority of its members didn't want to follow. And kind of we've seen after this, kind of in the political aftermath, Parliament's been charged with kind of frustrating the will of the people, things like that. So I wonder if you have, on the kind of point of irritation model, any way of resolving this, or whether on the legitimation model, I think that what that might mean is that Parliament shouldn't ask the people questions that they don't really want the answer to. So this maybe would suggest a form of referendums where before Parliament enacts a significant constitutional reform, it refers that reform to the people, and so a condition before the bill becomes law is that it's approved in a referendum. And I just wonder whether you kind of see that differently, or if you have a model that you prefer out of those.
Thank you very much. Alan?
Yeah, again, I think those two questions kind of map quite closely. So this idea of how, when can constituted power flip back up to the constitutional power, and is there room for those protest movements? I think absolutely yes. I think there is room to have that. If we're talking about this dialectic between rulers and the ruled, and we're talking about the ability of the people to challenge those who claim to speak on their behalf, we have to be thinking not just about the institutions themselves, but how the people can do that in other kind of democratic ways. So yes, there should be room for those processes. Then, and it should be for the constitutional powers to respond to that. And in that response, you know, and you getting, you know, constitutional reform out of that, in that relation there, that is where you get the, you know, the people actually being able to say this constitution responds to us. We do have ownership of the people. We're not just governed by this in other states, this document that was handed down to us hundreds of years ago. It is responsive, it is change, we do have ownership of it. So yeah, I definitely think there is a way for those, as you said, protest movements and for the constitutional powers to react and respond to them. And I think that potentially does tie it into your question on referendums, because I do think I do think we're seeing that. I do think, and I think in the paper I do call the Brexit referendum it's an irritant. It is a catalyst for change, but it's kind of one that I suppose the UK is really struggling. It is struggling to grapple with, arguably because it doesn't recognise the people as an authority, or you know, Parliament is still sovereign, and I think, and again, this is kind of what I've mentioned by a lot of my work seeming to being a little bit hindsight, because it's kind of like, well, if Parliament was aware of this inherent illegitimacy, maybe it would have been reluctant to put an advisory referendum to the people in the first place, and particularly actually interrogating that idea of the people. And who do we mean by that? And should it have been a UK-wide referendum, or should there have been other checks in places, for example, requiring majorities in each of the constituent parties of the UK? So that was the kind of thing that Aileen McCarr touches upon, but it wasn't actually delved in great detail. In terms of how do we get out of this mess? Well, either one, you implement the results of the referendum, or two, and I think, you know, cards on the table, 100%. I would classify myself as a Remainer, but you know, I'm an Irish person. We tend to like referendums and we tend to respect referendums. So if the UK is not to withdraw from the EU, I think the people should be invoked again in that regard. So I think that was to happen. I think a straightforward revocation of Article 50, I think, although absolutely legitimate under the doctrine of parliamentary sovereignty, I think that's deeply problematic from a democratic perspective. So I think a second referendum arguably would be more legitimate in that sense. If that answers the question.
Yeah, I think I agree with all of that. My point is really that I don't see the problem with the 2016 referendum, just that the UK Constitution doesn't recognise the people as a constitutional actor. I think the use of referendums is an attempt to do that. It might just be that it doesn't do it in the right way. So I think you are right that Parliament maybe was quite flippant in the referendum, the really skeletal referendum act that was enacted, and not really much discussion of what would come after that. But this is kind of really getting to my point in the first question, that Parliament shouldn't ask the people questions it doesn't want them to answer. So the kind of, if it's an affirmative referendum, let's say, where a concrete proposal is put to them that the majority of Parliament wants enacted, this allows constituent power and constituted powers to kind of complement each other. I think that's kind of the whole idea of constituent power, is that it's then enacted by those institutions that are supposed to represent the people. And maybe the way that we've had referendums up to now doesn't allow that to happen.
Yeah, I would agree with that. And actually, from an Irish perspective, that's how our system works. You know, a question is only asked that the Parliament, the Oireachtas, once actually answered in the affirmative. And at one time we did have a referendum that basically the government was divided upon and didn't actually want answered. Was the referendum to insert the 8th Amendment, the constitutional prohibition on abortion. So that was the only referendum we've ever asked that the government actually didn't want to ask in the affirmative, and that caused a lot of problems. So by doing that bit, and this is again, you know, you can use Schmidt here, basically the people don't decide anything, all they do is affirm a decision that's already been taken. You do the representative democracy bit first, and then you put it to the people for affirmation, and you potentially get the best of both worlds. They have representative and popular democracy. How you marry constituent power into that, yeah, it potentially is. It's the people being able to challenge and question those who claim to
Thank you very much, Alan. Great presentation, and I will definitely read your paper when it's out. Thank you, Mike, for great comments, and thank you, the audience, for fantastic questions and comments. And I would like to invite you to come back in a couple of weeks to see Conor Gearty from London School of Economics, who is going to talk about the Human Rights Act. Also constitutional law plus a little bit of human rights, more than today. Thank you very much.